Today's speaker is David Canon, who is professor in the Political Science Department at UW-Madison. He served as chair of the department from 2014 to 2017, and his teaching and research interests are in American political institutions, especially Congress. Professor Canon is going to talk to us about redistricting. He will place the Gill versus Whitford case in the context of previous court cases, tell us about the basic principles of redistricting, and give us the history of partisan gerrymandering. After reviewing facts of the case and the arguments for the state and the plaintiffs, he will speculate about the likely outcome and also tell us about possible reforms. We look forward to your presentation, Professor Canon, and as we've made a contribution to the Rotary International Polio Plus Fund as a way to say thank you for speaking with us. As we welcome you to the podium, please wait for the audience mics. We will be recording today. Thank you.
Well, thank you for that nice introduction. It's really good to be with you today. So the timing really was excellent for this talk today because the Supreme Court is doing oral arguments in Gill versus Whitford on Tuesday. And I don't know if Ron knew the timing of that when he asked me about speaking today. I certainly wasn't aware of the fact that the timing of it was so perfect. So today I will talk about redistricting more generally first to set it in a broader context, but then focus on the case that the Supreme Court will be talking about. And so the first thing I want to do then is to give, if I find the clicker here, to give a little bit of an overview in terms of just how redistricting works. And so every 10 years after the census, the U.S. House of Representatives is reapportioned to reflect the gains in population and losses in population around the country. And that's kind of step one of reapportionment. And then once the House districts are reapportioned, then the states have the task of drawing both the House district lines and then the state legislative district lines in each of the states. And that's redistricting. That will be the focus of what I'm talking about today, is that process of drawing the district lines in each of the states. Now, the process varies from state to state. There are currently 36 states in which the state legislature actually draws the district lines for their own House districts and Senate districts and for the U.S. House. Now that strikes some people as odd. Given one critique that's often made is that this is a situation where politicians are picking their voters rather than having voters pick their politicians. And so that is a general kind of critique that's made of this process of redistricting. Now, some states have overcome this, and I'll come back to this at the end when I talk about possible reforms. They've overcome this basic conflict of interest by having bipartisan commissions or a nonpartisan commission in some cases that will actually draw the district lines instead of the state legislature. So again, I'll return to that at the end of the talk when I talk about the possible reforms. Okay, so what are the principles involved then in redistricting? When the state legislatures draw the district lines, what do they have to follow in terms of the law? Well, there are two main things that we'll call the big two, and then lots of other secondary factors that come into play. So the big two are equal population and race. So going back all the way to the 1960s with the Baker versus Carr decision in 1962, where for the first time the Supreme Court entered what they call the political thicket of redistricting, they said that the idea of one person, one vote needs to be respected by state legislatures when drawing district lines. Because before then, they actually had districting done by county often, where each county would have, say, a state Senate seat. Well, you can imagine Wisconsin, if we would do that, then Milwaukee would have the same representation as a county up north with maybe a 20th or less of the population. Clearly, that's not equal representation in the state legislature. So that one person, one vote idea then said that you have to have districts of as equal size and population as possible. Now, for the U.S. House of Representatives, there's basically zero tolerance. You have to have them, as equal as possible. For state legislatures, they've had a bigger sort of margin of error, up to 10% in some cases, but most states try to get it within 1%. And Wisconsin has always been in that category of trying to have deviations no bigger than 1% of the population across districts, both the Assembly and the Senate. So that's one that we've had to follow since the 1960s as a matter of constitutional principle. The second then is race. And so since the Voting Rights Act in 1965, the Voting Rights Act amendments in 1982, race has also come into play in a big way in redistricting. And so after the 82 Voting Rights Act amendments, Congress said that racial minorities and language and ethnic minorities had to have an equal opportunity to elect candidates of their choice. And so this led to a huge round of Supreme Court cases in the 1990s and the 2000s. That's an entirely separate topic that we won't be getting into today. But that is something that state legislatures have to consider when drawing district lines. They have to make sure they're not violating the Voting Rights Act as well. So once you get past those two that are absolutely required, then you have a whole host of other considerations that come into play as well, of other traditionally followed districting principles. Compactness, so you don't want funny-looking districts. Contiguity, you have to have districts that are at least touching one another. In Wisconsin, we don't allow what's called point contiguity, where in some states, if you have two rectangles intersecting each other at a point, like two counties that are both squares, if they intersect at a point, some states consider that to be contiguous. Well, in Wisconsin, we don't recognize point contiguity. You have to be touching in some meaningful way. Also, respect for traditional boundaries, geographic boundaries. You don't want to split too many municipalities or counties. The communities of interest, to not split up communities of interest, and also try to avoid incumbent pairings when possible, and promote electoral competition. And so those are all things that state legislatures, including Wisconsin, try to do, but isn't required in the same way that equal population and race are required. So those are the main principles. So in terms of the focus for today then on partisan redistricting, partisan gerrymandering, the original term gerrymander actually came from a redistricting in the state of Massachusetts in 1812. And you can see the figure of the map in the upper right is actually from a political cartoon where that was the shape of the district looked like kind of a salamander. And the governor of the state at the time was Eldridge Gerry with Gerry. And so they took Gerry and salamander, put them together, you got gerrymander. So that's where the term comes from. And so we've been doing this for over 200 years. Okay, so this is a long-standing practice that both political parties, both Democrats and Republicans, for literally 2 centuries, have been doing this to try to gain partisan advantage when they draw district lines. And so, interestingly, the politics of partisan gerrymandering is not so much a Democrat versus Republican issue. It's a majority party versus minority party issue. And so unlike something like voter ID that has very strong sort of DR implications that Democrats tend to be opposed to strict voter ID laws, Republicans tend to be in favor because of the perceived partisan advantage they gain, with redistricting, that's not the case. It's whoever is in power, whichever party controls the process, wants to keep that process in their control and use it for their partisan gain. And so it's a majority party, minority party issue rather than Democratic versus Republican. And so if you look at some recent partisan gerrymanders from this most recent round, there are a couple cases like in Maryland and in Rhode Island that were done by Democrats. In North Carolina, Florida, Virginia, and Wisconsin, they were done by Republicans. And so this is something, again, that both parties have done historically. Both have been doing it recently. And so this is something that I think does bode well for the possibility of reform, though, because you don't have those locked-in partisan positions in a way that you would on some other issues. Okay, so that's the kind of basic background, basic principles. So how is this actually accomplished? How do parties actually use their redistricting power to gain partisan advantage, and how do they draw the lines to help themselves? Well, the two main tools are cracking and packing. So with cracking, you actually split apart your opponents and you put them in districts where they wouldn't have a majority to elect a candidate of their choice. Packing is the complement to that, where you'll pack as many of them into one district as possible or series of districts to have them waste votes. Because if you're in control, you want to win elections comfortably with, say, 55, 60% of the vote. To be in that range, it's kind of the sweet spot. Because you don't want to have razor-thin margins of 51. That's a little too nerve-wracking. But you also don't want to have 60, 70%, because then you're wasting votes. Like, you don't need 70% of your partisans to elect someone. So try for that sweet spot of like 55 to 60. Well, packing, when you're in the majority, you'll stick 70, 80% of your opponents in one district. And so this is just some examples of this recently. This is, again, I'll give you both a Democratic example and a Republican example. So this is a Democratic example comparing the Maryland districts, this is your U.S. House districts, from the previous round, comparing it to this round. So in Maryland, very Democratic state, they had 2 Republican districts in the previous round. The blue district across the top, the red district across the eastern part of the seaboard there. And so those were the 2 districts the Republicans had. Well, look what happened in this last round. The Democrats got kind of greedy. They thought, hey, let's leave Republicans just 1 seat rather than having them have 2. So they split up the blue district and they cracked it basically and took parts of that and gave it to 3 different Democrats and made it so the Republican who had been in that district for like 2 decades ended up losing. And he lost by like 20 points. It wasn't even close. And so one thing I wanted to share so you can see how egregious this redistricting gets in some cases, that blown up district in the left is the kind of orange district there in the Baltimore area. Someone called it a bug splatter on a windshield. Another person said it looked like an injured pterodactyl that had his wings injured and was splattered across the state of Maryland. And then someone also suggested we should give up the term gerrymander and just call it merrymander for the state of Maryland. And so this is a classic example of cracking then, where again, if you compare these 2 districts, look at that blue district, what happened to the next round, it's split up, it's cracked, so they end up losing that seat. Now packing, here's a good example of a Republican gerrymander in North Carolina, where in this round of redistricting, they packed all of the Democrats into those 3 districts, the blue districts there in the top map. And they end up picking up the other 10 seats in North Carolina. Now, North Carolina is a pretty purple state. Obama carried it in 2008. He narrowly lost to Mitt Romney by 2 points in 2012. And they have had a lot of Democrats both at the state level and in the U.S. House of Representatives in the recent past. This is a state that's pretty evenly competitive, kind of like Wisconsin in terms of the partisan split, but yet the Republicans took 10 of those 13 seats. Now, there's just a hypothetical map right below it of how the districts could have been drawn had the Democrats been in charge. So had the Democrats been in charge, they could have drawn the maps to gain 9 of the 13 seats for themselves. Had they been doing a Democratic gerrymander, it would have looked like that, and they would have picked up 9 of with the same vote results, with the same election returns. So you just take the vote returns and you just shift the boundaries around, you get a difference of 10-3 one way versus 9-4 the other way. And then the last one is a hypothetical map that shows that it doesn't have to be this way, that we can have districts that are drawn to be competitive. And so in this last case, you have actually 5 Democratic seats, 5 Republican seats, and 3 that are going to be competitive year after year. And so if you would draw maps more neutrally, you could actually have competitive elections in North Carolina. So that's kind of the classic example of packing. Okay, so what has the Supreme Court said about this? Because again, they'll be hearing the case on Tuesday. The Wisconsin case of oral arguments before the court on Tuesday. And they've taken this up several times over the past several decades, going back to 1986, a case out of Indiana, and then a case from Pennsylvania, the Jubileer case in 2004. And in both of these cases, the Supreme Court said that partisan gerrymandering is okay, that in those specific instances, you had the majority opinion, well, actually four conservatives on one side with Kennedy kind of in the middle, but Kennedy joined the conservatives in saying that it was okay in that instance. But then Kennedy, in both this case and then also the next one, the Lulac case, Kennedy wrote a separate opinion saying that while he didn't think that it rose to a constitutional violation in that specific case, he left open the possibility that at some point in the future, with the right case and the right measure, that this could be a constitutional violation. So you have the 4 liberals on one side, the 4 conservatives on the other side, Kennedy in the middle. And so Kennedy is going to be the crucial person in the Wisconsin case that'll be heard next week. And I'm not going to get into the details of the Lulac case, but I wanted to show how complicated that case was in terms of all the different opinions. And notice that Kennedy was involved in every single opinion. So he was trying to get his finger in each aspect of the ruling in that case, but with, again, the basic outcome was that the partisan gerrymandering in Texas was okay according to the majority, but Kennedy held out the position that at some point in the future, this could rise to the level of it's bad enough, and if we have a neutral measure that will allow him to say, when do we have a constitutional violation? And so that's what the reformers have been waiting for then is a strong case that will be able to convince Justice Kennedy. Well, the plaintiffs in Wisconsin are hoping that they're that strong case. So let's look at Wisconsin then. First, a little bit of background in redistricting in Wisconsin, and then look at the Gill Whitford case specifically. So one thing to note about redistricting in Wisconsin in this round, for the first time in the modern era, which again dates back to the post-Baker versus Carr era, so from the 1970s forward, this is the first time that one party controlled the Assembly, the Senate, and the governorship. So you can see the breakdown here of the last 5 rounds of redistricting of who controlled which chamber and the governorship. This is the first time that we had one party control all 3 of those parts of state government. And so when you have, say, one, even just the Assembly or just the Senate or a governor who's willing to veto a plan, you can't have that kind of partisan gerrymandering because the side that is being left out is not going to put up with it. And so you can see what typically happens in that case is it ends up in federal court. So in the 80s, 90s, and 2000s, federal courts actually drew the Wisconsin maps because the legislature couldn't agree. You couldn't get a compromise position where Democrats and Republicans could agree. And so in those 3 decades, you actually had the courts drawing the maps. So this time in 2011-12, Republicans control the Assembly, Senate, and the governorship, so they're able to draw the maps to their liking. And that then is the Act 43 that they passed that creates the districts for the state legislature and for the U.S. House. And so August 2011, this goes into effect. And it was a very successful partisan redistricting that they, with mathematical precision, were able to draw district lines that led to having the Republicans gain only 48% of the vote in the total votes cast in assembly races, a little less than that statewide for president, yet they're able to gain 60 seats in the assembly. And so this was, again, through this ability to pack voters into some heavily Democratic districts and then to divide voters, Democratic voters across other districts, and to pick up those more competitive seats they were able to do with the redrawing of the lines. So these maps were challenged then in July of 2015, and the case went to federal court. And so it's a 3-judge panel comprised of 1 judge from appeals court, 2 judges from the district courts. And this is fast-tracked into the Supreme Court. So unlike the normal process of litigation where it goes district court, appeals court, Supreme Court, here they combine those first 2 steps with the 3-judge panel. So that's where the case was heard. So the arguments then of the plaintiff was basically that the plan was such an egregious partisan gerrymander that it violated both their First Amendment associational rights and their 14th Amendment equal protection of the laws, saying that this was a constitutional violation of basically their right to associate as Democrats, but also that they didn't have an equal opportunity to be represented in the legislative process. And so this was the constitutional basis for the claim then. And also, and critically, this last point on the efficiency gap is another point that is going to be very important next week when the Supreme Court hears this case. Will this be the long-lost measure that Justice Kennedy has been looking for, of a neutral, easy-to-apply test that allows you to determine whether or not a violation has reached a level where it is a constitutional violation for partisan gerrymandering? And this is the efficiency gap idea, where is a very simple, intuitive notion of just the relative proportion of wasted votes for the 2 parties. And a wasted vote simply means any vote that's more than 50% on the winning side, or any vote that's cast on the losing side. And so the relative proportion then of those total wasted votes for the Democrats minus the total votes for the Republicans divided by the total number of votes gives you this efficiency gap measure. And so it's a relatively easy, in fact, very easy to measure instrument to look at. And so the experts who testified in the court case looked at all redistricting plans in the United States going back to the 1970s to see how Wisconsin stacked up compared to other states. And so this is going to be one of the critical things in the case on Tuesday. Now, on the other hand, the state's response was, well, a couple critical points. One was to say that the efficiency gap really isn't something that we should pay that much attention to because there's no constitutional right to be protected rights as a Democrat or Republican, that the court has never recognized partisanship as a characteristic that deserves constitutional protection the way that, say, race does, or gender, or ethnic identity, or language minorities. Partisanship has never had that kind of protection, and so the efficiency gap really doesn't measure anything that's meaningful in a constitutional sense, because it doesn't actually protect something that's a constitutional protected right. And so that's the first point. Second, they said that even if we will grant that there's something to this constitutionally, the maps can still be defended on traditional districting principles. That neutrally drawn maps would still have a Republican bias in Wisconsin, they argued, because Democratic voters are more concentrated in Milwaukee and Madison. And so even if you had neutrally drawn maps, the maps are going to be more efficient for Republicans in the state than for Democrats, because their voters are just naturally more efficiently distributed across the states, whereas Democrats are packed into the two main urban areas, and therefore they're going to have more wasted votes just by the nature of where people live. And so this is the other sort of main part of the defense, was to say that even neutrally drawn maps will actually still have that efficiency gap. And they, in fact, and I'll show later, they argued that the maps that they did draw were basically in line with other measures on traditional principles like equal population compactness and so on. And so that's the main part of their defense then. Okay, so what did the evidence show then in the trial? Well, if you look at the maps, they're actually, they don't look like those crazy Maryland or North Carolina maps. You don't see any districts that have these wacko bug splattered on the windshield kind of look. So the three maps shown here are the old maps from the last round on the left, the demonstration map that the plaintiffs provided to show that you don't have to have a partisan gerrymander to get a much better efficiency gap with lower wasted votes, than the actual plan on the right. So the one on the right is the one to kind of focus on here. And again, you can see that just kind of the eyeball test, there's nothing crazy going on there in terms of the way most of the districts look. And so on that ground for defense, there's certainly something to that. But then when you get deeper into the data and start to look at the efficiency gap measure in statistical terms rather than a general kind of eyeball test, this came from Simon Jackman's expert report in the federal court case. He's a political scientist from Stanford University, and he did all the analysis for the plaintiffs on the efficiency gap. He took every single state legislative redistricting map going back to the 1970s and figured out the efficiency gap scores for each state, and then ranked them from left to right, basically, in terms of the biggest Republican advantage to the left, the biggest Democratic advantage to the right, and the big vertical line down the middle is 0. So that's a perfectly fair map, is the 0 line in the middle, and then the bigger, again, Republican gerrymanders to the right, the bigger Democratic gerrymanders, to the left, and Republican Democratic gerrymanders to the right. And so you can see that the red line on the bottom, that's the Wisconsin 2012 map. And so that's like out of the 732, I believe, plans there were, it's the fourth most extreme gerrymander on the Republican side in the last 5 decades. And so this is clearly out there on the tail of the distribution in terms of this efficiency gap measure. And not only that, if you combine 2012, when it had an efficiency gap of 0.13, with 2014, when the efficiency gap was minus 0.10, that's the biggest back-to-back gap of any one of the 732 plans. So there had never been a pair of elections that had that big of an efficiency gap back-to-back. And so Simon Jackman's testimony then was that it may be hard to know exactly where to draw that line, but he drew the line at 0.07. He said that that's where, if you're above 0.07, that's a serious gerrymander that's likely to persist for the decade. But here in Wisconsin, we were at 0.13 and 0.10, and so those are clearly out in the tail. Now, how did this happen then? Well, here's one example, and there are lots of examples from the plaintiffs in the court case. But here's what happened in Sheboygan. So again, the map on the left is the way it used to be in the previous round. The map on the right is the one that actually was implemented, and the one in the middle is the demonstration map that was to show that it could be a more fair map. The map on the right is blowing up the Sheboygan districts then. And so the old district is kind of in purple, and the new district, where you have District 26 and 27, now cut Sheboygan in half. So you used to have a Democratic district. You can see in the map on the left, District 26 is that little blue dot on the shore of Lake Michigan there. It was a Democratic district, and because like 86% of the population from District 26 was from Sheboygan, Democratic voters who were predominant in the city, and they always had a fairly safe Democratic seat there. Well, with the redistricting, they employed the tactic of cracking, where you split apart Sheboygan in half. You put half the Democrats to the north, half the Democrats to the south, and all of a sudden, you can see with the current map, Republicans pick up every district in the area, including the divided Sheboygan. And that technique was replicated across the state in many other urban areas where the voters were split apart. And so Republicans were able to gain advantage through that cracking technique. Now, here's another way of looking at it more systematically, where you look at the distribution of the election results, where the Republican vote percentage from 0 on the far left, 100% on the far right. And remember where I said that the sweet spot was sort of 55 to 60? Look at that sweet spot. 26 districts out of the 99 were in that 55 to 60% sweet spot, with another 12 in the 50 to 55. Because that's where you're not wasting votes there. You're able to have the Republicans' votes used efficiently by putting them in those districts. Look at the Democratic districts. Only 3 in that 55 to 60 range for the Democrats, 3 more in the 55 to 60 range for the Democrats, because it's percent vote Republican. And so now one thing that this bar graph shows is the actual vote totals. And one thing you'll notice is there are 23 uncontested districts for the Democrats, and so those are the packed districts, and only 4 for the Republicans. Again, more evidence of kind of the packing there. But then this is probably a better way of trying to gauge the overall kind of effect of the districts, is looking at the sort of imputed, the expected vote in the districts. So taking out, so not the actual returns, but imputing it with a statistical analysis to see what's the expected vote. And this is what the expert for the state, Keith Gaddy, in his expert testimony for the state, presented with his measure. Their expectation was there'd be 24 districts in that sweet spot of 55 to 60, 21 more districts in the 50 to 55. Again, for the Democrats, they only had 21 in that whole range, and you have 45 Republican districts in that range. And so pretty clearly then, this was a very successful attempt, and they were able to do it, of having the Republican votes used more efficiently. And it's shown both by the efficiency gap measure and also by looking at this aggregate kind of results like this. Now, again, going back to that demonstration plan, the one that the plaintiff showed that it wouldn't have to be a partisan gerrymander, just like that North Carolina map that showed 5 Republicans, 5 Democrats, and 3 competitive. Well, here's what a competitive distribution would look like in Wisconsin, using the same vote totals and just drawing lines to try to make a more efficient map in terms of the party competition. Here you can see that it's very even between the two parties. And so you have 27 Democratic districts in that competitive range of 50 to 60, and then you have 29 in the Republican districts in that range. So a much more normal shaped distribution of the districts that are, more of them are competitive, whereas in the actual map you had that clumping of the competitive districts on the Republican side and away from the Democratic side. And so this was a key part of the plaintiff's case, was to say that, look, we can do better by having a more neutrally drawn map. Now, the state of Wisconsin countered by saying, as I mentioned in their overall kind of arguments for why this was not a problem, is that the plans did not violate traditional districting principles. And so if you look at things like population deviation and compare it to the demonstration plan, so this is again the one drawn by the plaintiffs, you can see there's actually less population deviation, 3/4 of 1% compared to 0.86 in the actual law that was passed. The compactness, the districts are a little less compact by this one measure, but it's not like way out of bounds. In fact, they argued that the current plan is quite similar to the one that was drawn by the federal courts in the last round. It's a little less compact, but it's definitely in the same range. And the number of split municipalities, another traditional principle that I mentioned, you can see that the state plan splits a few more municipalities, but not a lot more than that demonstration plan that the plaintiffs came up with. And so that's the core of their defense end, is to say that, look, this has never been a problem. State legislatures always have drawn district lines. This is always, again, going back to 1812, we've been doing this. And so this is not a problem, especially when we have not violated traditional districting principles. So what did the court decide? Well, so in November, this last November, by a 2-1 decision, and there was one Reagan appointee, one Carter appointee in the majority, and then a Bush appointee who was in the one against, who dissented. But they basically sided with the plaintiffs in saying this was a real problem. They recognized the state's claim that other things do explain some of the efficiency gap, the fact that Democrats live more, in densely populated areas, but they said it doesn't explain enough of it. And they said that there is evidence that this was kind of an extreme application of drawing districts that did help the Republican Party, and that it would be durable and last over the decade. And so they had an intent standard, so they had a 3-pronged test, then an intent standard. Was there intent to discriminate based on party? And they answered that yes. Did it have an effect that helped the majority party? They answered that yes. And then can it be justified on other legitimate kind of grounds? And they said there's some evidence for that, but in general, you could have had a much better map than the one that was drawn. And so pretty much down the line, they went with the plaintiffs' arguments and ruling against the state. And so the appeal to the Supreme Court then, as I mentioned at the beginning, will all come down to Justice Kennedy. It really is, is this efficiency gap measure going to appeal to him in terms of what he's looking for that neutral measure that he wants to tell him when there's a violation, or not? And that, because you have 4 pretty much locked in on one side, 4 locked in on the other, and Kennedy then is going to be the decisive vote. Now, reading the tea leaves, it's always a little difficult, and in a way, it would have been nicer to have this talk next week after oral arguments, because then you have a little better sense for what's going to happen after you actually get to hear what the questions are like, and especially everyone's going to be watching Kennedy to see what kinds of questions he's asking. But there are some hints, and one of them definitely leans towards the state, and the other, I think, is probably some good news for the plaintiffs. And the one that is in the state's advantage is the fact that the court back this summer decided not to force the state of Wisconsin to draw the district lines now before the Supreme Court ruled on the case. And so in order to have that ruling, they basically have to have at least some sense that the state will be able to win on the merits. And so it was definitely bad news for the plaintiffs when they decided to go that route. Now, on the other hand, at the same time, when they agreed to hear the case early in October, they leapfrogged that case over several other cases that already had been on the docket. And so that's something that normally they don't do. And so people are speculating that maybe that's a signal that they do want to get this wrapped up in time for the 2018 elections and still have the state of Wisconsin redraw district lines. So it's hard to say which way that goes, and you definitely can put a spin on that either way. Now, to make it even more complicated, there are 2 additional ways they could punt. And this is something that John Roberts often likes to do in a controversial case, where he likes to try to find common ground where you can get 9 votes for something, or maybe 7 or 8 votes for a position, and defer the tough decision to later. He has done this repeatedly on big cases, and you would have potential to do that here in a couple of ways. One is the question of standing. One thing the state of Wisconsin is asking the Supreme Court to do is to basically kick the case out, saying that the plaintiffs don't have standing, because they don't have plaintiffs from each of the 99 districts. And so they say that the statewide plan can't be challenged. There's no personal injury that's coming to the plaintiffs if you don't have plaintiffs in each of the 99 districts. My sense is that's not likely to be something the Supreme Court will agree to, because if you look back to the LULAC case, that question came up, and not one of the 9 justices questioned the focus on the statewide map in Texas. So I think they're probably not going to go that route. But the second one is more possible. I don't know how likely it is, but it's definitely possible the Supreme Court could punt by remanding it back to the federal court, the 3-judge panel, to have another trial based on this new 3-pronged test that they just announced. Because the state said, hey, look, we didn't know that's what you were going to do. Let us defend our case based on this three-pronged test, and let's have another trial. So that would be one way the Supreme Court could punt, basically, would be to go that route. And I think, I'm not a betting man, but I would say it's almost split equal thirds, where Kennedy could go with the plaintiffs, almost equal likelihood of going with the state, and another sort of equal likelihood of a third of saying have another shot at it and remand it back to the federal courts. So just real briefly, I know I'm running out of time. I do want to have time for a few questions. I won't talk much about this. We can leave this more for the Q&A if you want. But there are possible reforms, and this is something that, again, is a majority party, minority party thing. And the majority party never wants to give away that power voluntarily. And the Democrats had that chance in 2009, 2010 when they controlled state government, but they didn't put in a reform that would take that power away from them and give it to a bipartisan commission. And the majority party just doesn't have an interest in doing that. So typically when it has happened, it's been voters that have taken the power away from the states through the referendum process. And that's something that where states have initiative and referendum, they've been able to do this successfully in 14 states. And so bipartisan commissions are one way to go. Non-partisan processes, I think, are better than bipartisan because, like Arizona shows, that the bipartisan thing can get to be a mess too, where they just are still at odds with one another. Whereas you have like the Iowa model, where it's a non-partisan legislative reference bureau that makes the maps, and the state legislature has to vote them in or up or down just on a vote that they can't amend it. I think that's probably a much better model. And then finally, a more extreme solution that some reformers talk about is having multi-member districts. So it's harder to gerrymander in bigger districts than smaller districts. And the state of Illinois actually had this from 1870 up through 1980, where in each state Senate seat, you had 3 nested assembly seats like we do in Wisconsin, but voters would get to have 3 votes in each of those multi-member districts. And if you want to cast all 3 of your votes for one politician, you can do that. If you want to split them 2-1, you can do that, or 1-1-1, you can do that. So what would happen in almost every one of those sets of 3 districts, you'd get 2 Republicans and 1 Democrat, or 2 Democrats and 1 Republican, depending on the underlying nature of the district. So it gives a much more sort of balanced, bipartisan kind of approach to redistricting by having that approach. Again, I'm not too optimistic that's going to happen because the majority party would have to sort of give up their power to be able to draw the district lines. But that is at least another thing that reformers are talking about. So I'll open up for questions for the remaining time that we have. Thanks.
Hi, thank you for your presentation. My name is Mark Moody. I guess I have 2 questions. The first is it worth saying anything about what the dissenting judge said in the appeals court? And the second is, what does this all coming down to Kennedy tell us about the Supreme Court in general and its sort of nonpartisanship or neutrality?
Yeah, so I'll take the second part first. And clearly, with Kennedy being the deciding vote in so many of these recent cases, it does show that ideology, I think, is increasingly important on the Supreme Court in these big cases. Now, it's not to say that the rule of law is gone with the Supreme Court. Obviously, it's not the case. You still have a lot of unanimous opinions on the Supreme Court where all 9 of them agree. It's just that we hear more about these divisive cases. And in the closely divided cases, it does often come down to, is this a more liberal judge or conservative judge, with Kennedy being kind of the swing vote in the middle. So I think it does show the importance of ideology on the court. And there's a huge literature in political science that tries to unpack that relative impact of the law and ideology. And there's evidence, obviously, that both matter, but there's no doubt that ideology matters too. Now, in terms of the dissent in the 2-1, the 3-judge panel, one of the things, it was a couple things. One is that he was not that enamored with the efficiency gap measure, that he said that there are some problems with it. Like, for example, why do you take as the baseline a wasted vote away from 50? Shouldn't it maybe be away from what the electoral margin was for the actual percentage? So let's say they won with 53% or even 47% if you had a third-party candidate running. And so you could get a different efficiency gap if you used a different baseline. And that's certainly a possible critique. Also, he was just skeptical of this notion of constitutional rights for partisans. And so he just was shying away from that basic conclusion as well.
Hi, thank you. I'm Karen Kendrick Hands. So the flaw we're saying is that this kind of map drawing reduces the number of contested districts. So do you see a different kind of district drawing as bringing us back to more bipartisanship because general elections will count again?
Yeah, I think so. And I think it's a good question in terms of would more competition lead to more bipartisanship and more ability to work with each other. I think that it would, because if you had maps in Wisconsin look like that, where you had 34 of your 99 districts were in that competitive range. Exactly a third of the people who were representing the state of Wisconsin knew they'd have to go back to the voters and face the voters in election in a contested election. And so I think that's really different than an election like this one, that we had the actual election results, where we had 27 of our representatives who literally didn't have to face the voters at all. They were unopposed. And so there's no doubt that if you had more competitive elections, so here you have 17 instead of 34. So it's exactly half as the number of districts are in that competitive range. So I think there's no doubt that if you had more competition, that does make people have to be more centrist, because you know that you have to appeal to those independent voters that are more in the middle. You can't just appeal to the more extremes, either on the left or the right. So I think it would have that beneficial side effect for sure. So, great. Okay, well thanks so much.
Thank you, Professor Canon. Very interesting, and we will stay tuned. We are adjourned.